Okay. Okay. We'll go ahead and get started. My name is Danielle Simpson Alford. Let me go back. Um, we'll go ahead and get started. My name is Danielle Simpson Alford. I am the founder and managing attorney here at Georgia Teen Legal Defense. It is a law firm that just handles juvenile defense and juvenile cases. So we have an open house at the firm, which basically means that once a month we give the opportunity for people to come in, hear a little bit about what we're doing, learn a little bit about the law, and then at the end we'll have like breakout sessions where actually you can have like a mini consultation to answer some questions that you may have, or if there's some concerns that you have, we can also talk about that as well. So this month, which is the month of November, we're talking about the age game of juvenile law. So we'll briefly talk about that. We'll do an introduction, we'll talk about that, and then we'll get to the breakout rooms because I want to be mindful of all of your time. So again, Georgia Teen Legal Defense, or GTLD, is basically here to help teenagers, kids, and families to understand the system, and also to help them navigate with like confidence and get the support that they need. That means in the school, in the community, in the classrooms, outside of it, anywhere that kids are and need that kind of assistance, we're here to help. And so the purpose of this is just to be able, I think that there's a lot of questions. I get a lot of questions at community events, where it's like, I have a kid that's in, has this situation. What do we do? How do we support them? Community members, family members, church, people who are in the community, church members, anyone. They want to know more about juvenile law. So this is how I'm doing this, putting myself out there so that you get to know me a little bit in case you want to hire me for any services that you may have, and then also kind of just explaining how the law works so that everyone is like more informed and has more information. So again, my name is Danielle Simpson Alford. I am the founder and managing attorney. I started my career at the Fulton County District Attorney's Office. I actually started doing a court watch program, which essentially is community education. So I've always really been like a grassroots lawyer. That's what my firm stands on, and that's the hope that we're bringing to the community, is just somebody who they know. I've always received phone calls or questions, and so I've always been like attainable and accessible. And that's really what my firm is about, is to be out in the community, a grassroots effort to try to, help people and probably the most difficult time that they're having with their kids. And so, like I said, I started off at the Fulton DA's office. I did that program, and then I ended up being a community prosecutor for English Avenue, Vine City, formerly known as The Bluff. And I did a lot of drug trafficking prosecution. And in that, really realizing, again, the age of majority being 17, which is what we're going to talk about today, and then also a mandatory minimum for trafficking of 10 years, those types of charges mixed with those types of offenders, it just didn't sit right with me. And so I kind of pivoted my career towards juvenile work and ending up at the Douglas County District Attorney's Office, where I was the deputy chief over the juvenile division for several years, leaving there and working in the truancy intervention project, where I was the senior staff attorney. And I currently volunteer with the organization and really help them kind of figure out the school pieces, right? So there's only 10 unexcused absences allowed. And so, helping them kind of navigate why they're not going to school, and also protecting their rights within the school building. I transitioned then on to the senior staff attorney at the Georgia Public Defenders Council, where I did delinquent defense. And I also volunteer currently at the Safety Valve Project that specifically works on school discipline cases. And so those are like tribunals, long-term suspensions, things like that. So, all of the work that I've done for a very long time has been rooted in juvenile work. It's my life's mission. I think that's what makes our firm different, is that we do this work. You'll see other attorneys that will say we do juvenile work, and that's a part of their firm, the small part of it sometimes, but this is all we do. This is all we do. So there isn't other things that we do within our practice, which will make it feel more comfortable that we're experts in the law, been doing this for a very long time. We know what we're doing. I have worked in multiple counties throughout the state. So I'm not just in Atlanta. I've been all over North, South, East, and West in Georgia, addressing these issues and concerns. So my hope is that you feel really comfortable with the background that I have and the expertise. So what we do, again, is we offer comprehensive legal support for children and teens wherever they face legal challenges. We do juvenile delinquent defense, so that's like crimes when kids are getting in trouble. Again, school discipline, truancy, education, 504s, IEPs, any of that special education work. We also do a lot with dependency if kids are involved in DFCS, if there are parents who are looking to, do private filings to, there's a child that they think that they could take better care of. I do emancipation cases. Sealing records is something that they'll ask for. Kinship care if you're staying with like a family member, but you guys want to do it, temporary guardianship, all of those things that are really impacting a child's life. We focus on whole child trauma informed advocacy. So we don't our goal is not just to get the kid to basically admit or deny and move forward in the legal process, but we're also making recommendations in regards to what they need, connecting them with resources and services, making sure that we're being mindful of the trauma that they have gone through, and then tailoring our representation around that, which again is just another facet. It's not like a certificate or a designation. It's just another way to handle cases and know that you're doing it in a way that's not going to cause more harm than good. The other piece that I think is really important too is we are really client-centered decision making. Like I tell my clients, they don't know what this is every time I say it, but I'm MapQuest and they're in the driver's seat. So they are the ones telling me what it is they want to do, how they want their cases to go forward. I'm advising, but I'm not driving. So I'm MapQuest and telling you, what the road is closed and if you should take a right or a left, but you're the one who's in the driver's seat. And so you decide the direction that we go. And I think that's really different too, when you hear sometimes kids say like, well, this attorney said I had to, or, I've had clients say like, well, I admitted because they said if I didn't, then, this would happen. I don't do that. You want to try a case, we'll try it. If you want to admit, you can admit. It's up to you, but I'm never going to force you anything because it's really not my case, right? It's not the parent's case, it's the child's case. So they're the people who are in the driver's seat, which sometimes is frustrating for parents who want to be there, but this is kind of how we support them. Sometimes these are the most critical decisions that kids are going to make, and they're the most important in a really difficult time. So we give them the autonomy to make those decisions and support. And again, we handle any legal matters involving youth. So anything that comes up that involves a kid, we're here to help. So the next thing that we're just going to talk about again is like why we exist and why we're here. We really feel that at the end of the day, teenagers and kids really need representation. There's a lot of things that happen with my clients in the school and outside of it that they aren't really understanding. Parents feel overwhelmed, they feel unsupported, they feel like they're being pressured or forced into certain things. And so they just don't know. It's a really niche like area too. Not everyone does juvenile work, not everyone understands juvenile law. And so it's really nuanced. There's a lot of terminology, there's a lot of things that are going on. And sometimes like the schools and courts can be really inconsistent. So even if you search things, there's not a lot of information. And so we try to bridge the families, the courts, and the community together to assist children in where they're finding difficulty. And we really truly believe that all of them deserve to be heard, protected, and guided, and not judged for their mistakes. The goal is to teach them the errors of their ways, if any, and then also to protect their rights and get them to be productive members of society. And I tell people all the time that, we want people, when kids come in, they have interactions with the criminal justice system, we want them to feel that they are heard, and we want them to feel that it was fair. And if they don't feel like the criminal justice system is fair at 12 years old, then what kind of adults are we going to produce? So we really believe that. So again, I'm going to move into our topic of the month. Like I said, each month we highlight just a different topic related to child welfare as well as juvenile justice. And we talk about a range of different issues, but we just want to kind of explain the law a little bit more. We won't talk for a long time, but we just wanted to hit on it. And so this month we're really talking about what the law says about age. And so what a lot of people don't know is that 7 is actually the age of like juvenile court. It starts at age 7. So you're talking maybe first or second grade, right? And that's the minimum age of criminal responsibility. We don't see children that young because there's this other thing called competency, which trying to figure out if they understand the rights and the consequences and actually can like assist in the defense in their case. But I have clients, that are 10 years old, 9, 10, and 11. So they're very young. And so there's a lot of emphasis on needing for early intervention, which I found really frustrating sometimes when I, am talking to other stakeholders and they say, yeah, let's have a discussion with 16-year-olds. And I said, if juvenile court starts at 7, then we need to be meeting with them sooner to explain to them how things work. Kind of the same thing with the next point is that age 13 is when juveniles can be charged with serious violent felonies. Those are murder, rape, armed robbery, some of the things that you would hear. We call them like this, they call them the 7 deadly sins. And then they also call them SB 440s because they're state bill actually defines what they are. And that is when a youth can be transferred to superior court or where their case actually is charged in superior court. And so that ends up taking the child completely out of the juvenile system. Now, there is options to transfer them down to juvenile court, and there are opportunities for certain charges to be transferred up to superior court with like a threshold, which we can talk about at another time. But again, these are your serious offenses in which, we're talking about them actually being in superior court and not in juvenile court. So juvenile court is a court of services, treatment, and rehabilitation, and superior court is to punish. So you have children that are very young being punished for things that they may not understand. And then again, we talk about like the disparities based on race, based on where they live, school discipline history, all these things kind of come into play. And then the last one, so I always say 7, 13, and 17, Georgia treats 17-year-olds as adults for criminal liability. It's one of, I believe, 5 states left that does that. And so a lot of teenagers will commit offenses that are the same that they have committed before, but they're 17 and they go to county jail and they're not 16 going to juvenile court. A fight at school, something like that. So although we have children who they're not 18, they cannot vote, they can't, enter into a legal contract, they can't do all the things that you do as an adult, they're facing criminal charges. And it's a gap. The 17-year-old is like, it's a gap in the system where they, don't fall into the category of juvenile, but they also aren't an adult and they just really like fall through the cracks. It's kind of like, we call it like minding the gap, and that gap between the adult platform and the adolescent platform, and they just kind of fall in between. And that means, some kids are walking before they can even do anything, they are already having a criminal history, which creates barriers for them for employment and housing and college. And so those are things that are really important for people to know. So that's essentially the age of juvenile court and what that means. And we can definitely talk about it or answer any questions as well. Let's see. And the reason that this matters and that it's important is because, again, age definitely determines the rights, risks, and outcomes. Teens are very scared. A lot of people don't know. Like, as soon as I tell someone like, hey, but they were 13 and it's an armed robbery, and they're like, what? I don't understand. How could you have no bond? Why, are we in this adult system? And I think it's also like families do definitely need to have like clear information, and kids as well. That's why I do so many know your rights events for parents, for kids, for communities, so that everyone knows. Because when you know better, you do better, and then you can move in a different way. And so we're here at GTLD to basically protect rights for kids even before that mistake becomes a lifelong consequence. And so that's intentionally the goal. All right. So like I said, what we also do is at these meetings is we have a consultation, and the purpose of it is just to have like a brief session for you guys to kind of talk. If there's a question that you have, or if you have a certain circumstance that you want to discuss with me, just a couple of rules or disclaimers. This consultation does not create an attorney-client relationship. The information provided is general legal guidance. If it's free and it's confidential, for the client that I'm speaking with, but for full representation and specific legal advice, then you should retain us in order to help you with that. But with that being said, I'm going to put everyone in breakout rooms, first come, first serve, and we'll chat about cases. Thank you so much for being here, and I'm excited to working with you in the future.